on the troll.
Hello and welcome to Mzansi. We're back again. It is that time of the night where we have to deliberate and deliver to you as usual. Obviously, there's something that happened in court, and we have to update you on what happened. And we are here to do so. We are hoping that we're going to do that in peace because we have, I think I got something that tells me that it's going to be load shedding, but I'm taking my chances as usual. And I hope that you guys enjoy. Greetings.
So yeah, guys, welcome back to the Mngomezulu Reality YouTube channel. Thank you so much for joining us yet again for another deliberation of the Senzo Meyiwa Trial. Now, a lot happened today. I myself personally feel overwhelmed, and on top of that, I feel like, come on, we already know. We know where this is going to go, you know? It was quite telling today to see the judge interrupt Ramosepeli multiple, quadruple times, not giving him a chance to argue. In fact, he was the one arguing on behalf of the state with Mr. Ramosepeli, which I found very strange. At every turn, he was disturbed, interrupted. It was awkward.
Right. Just to do our normal convo, just an update. This is an update.
Okay.
That is very important.
All right.
And I know people get offended, but hey, man, we are brothers here. What I'm about to say is that Orlando Pirates won against Kaizer Chiefs during the weekend. We had to say it, man. We had to say it. We had to say it. Yeah, but because we Buccaneers don't talk much, I'm not gonna give you grief on that. Just gonna say that we won 3-2 after several times of scoring first, as usual. Ladies first. Yeah, so eventually we finished it off. Yeah, and it was a great feeling, Emily.
I'm glad you are happy.
Are you supporting Kaizer Chiefs?
No.
Okay.
I'm just worried about our people who are Kaizer Chiefs fans.
No, there's nothing wrong with that.
Listen to you rub it in.
There's nothing wrong with that. They were going to do that exactly.
A lot is happening in Kaizer Chiefs right now. Fans are not happy.
Yeah, I know.
They are not happy.
People are crying. I saw their miss crying. Very sad. But let's continue.
Well, the defense continued with closing arguments in the trial within the trial today. And Sipho Ramosepeli made his submissions. He said he will first respond to a claim by the state that the grounds for the defense's objection are unclear and contradictory. Ramosepeli said, with respect to the admissibility of Exhibit FF, the objection that was raised does not contain the constitutional ground. The reason for that objection, the statement was not obtained freely and voluntarily since accused number 1 was assaulted by police. Ramosepeli said that he was threatened that should he not complete the pre-written statement, he will further be assaulted, and he further testified that he is not informed of his constitutional rights. Ramosepeli said accused number 1 testified that he was assaulted at Lethabong after his arrest. He was then taken to Vosloorus, where he was also assaulted by police officers, and further he was taken to Diepkloof. That is on record. Ramosepeli said, I want to refer Advocate George Baloyi, stating that we put contradictory reasons forward. Okay, that's what the argument from Advocate Baloyi came to say, that they are putting contradictory statements forward. Ramosepeli said that he disputes that there were 2 cars, and he said that there were at least 7 cars involved. All the officers involved in his assault denied that he was assaulted, and Ramosepeli pointed out to when Sibiya was arrested, and he said that the handcuffs were so tightly fastened when he was arrested. He highlights the excruciating pain that he must have felt when he was lifted up We all remember the definition of that tactical takedown, and the fact that accused number one was saying that, you know what, they would even lift me, by the handcuffs. And of course, the police officers who were there, Mohani in particular, denied this to say that they never lifted him like that. They lifted him properly. They lifted him so soft in a tactical takedown. Yeah, this is when the assault started, according to Ramosepeli's argument. So the injuries to the wrist then goes to the OBs in Valeria SAPS. The entry in the books cannot be true, because how can you miss the injuries that are on the wrist? He even further argued to say that his learned colleague Mr. Baloy was likening those marks and spots that who filled it in? Who filled in on the OB that he had marks and small marks on the wrists?
And indeed, that is a good argument, because if you accept the marks on the wrist, and then you say in
But
that
they're
OB
small.
no injuries, that is wrong. What is injuries?
He literally minimized them. That's why even Baloy is arguing that it was compared to markings of a wristwatch.
No, it does not matter. The fact that you are noticing and you are admitting that there were injuries, then you should have written that down to say injuries on the wrist, not sure where they obtained them. Do
You
you
can
understand?
always ask them, where did you obtain them? And they tell
Or
you.
they tell
write
you
it
where
down.
they obtained them. So,
If it was an honest country with
yes,
honest people working in the police.
that is true. So it doesn't make sense. No matter how much you minimize them, the fact that you have acknowledged them, they should be on an OB book.
And you know how
Or they should be on that performer.
And you know how even the accused testified that I still have markings. And of course, the presiding officer didn't care. He would demonstrate to the interpreter, even Ramosepeli brought it up, that he still has markings, but they didn't even consider
Those
it.
so-called small
They
markings
didn't
that
even matter.
a normal judge would have said, okay, come close. I want to see those small markings.
I didn't care, that one. That one was like,
If
what?
these are the same ones, I want to see. Just come. Let me see those
I
small.
don't care for those markings. They are none of my business. For all I know, you could have given them to yourself.
Or you could have been hidden by the grandmother at home.
Like the other one was
looking
claiming that
for
to
chicken.
striking a chicken. Ay, sukan matota. Ramosepeli then moved to the pro forma documents that were filed at Deep Kloof. He said that Colonel Boto failed to interrogate further a question on the circumstances accused one was making the confession under. Now, he said the question is vague and ambiguous. Ramosepeli said that no further answer was solicited from the accused from this question. So this answer created an air of suspicion that the accused was told what to say to Mboto. So Ramosepeli said, Colonel Mboto minimized the extent of the injuries on accused number one, and Ramosepeli now moved to the blood spots and swollen hands that Mboto noted, and accused number one said in Tembisa when he was arrested, Maphumulo lifted him with the handcuffs, and he said, I don't wish to be accused number one, but you can imagine when your body is lifted by your hands. Ramosepeli said, accused number one testified on all three occasions.
Which is in line with the injuries on the wrist.
Yes, if you're lifted like that, definitely you're going to be injured on the wrists. It doesn't matter whether they were fastened small, tight or not. You will get injured on your wrist if you're lifted like that.
Okay.
So Ramosepeli then said, accused number 1 testified on all 3 occasions where he was assaulted. The main mode was a clear plastic bag. He could not breathe. What sort of injuries would you see if a plastic bag is put over your head? Which are the same questions
from the camera.
have as Mzansi reality.
Can you capture that on a camera that is not even 4K?
Can you? You know?
Even a 4K, I'm just saying, because I know they are using those old ones.
And also how would he have been able to? He did mention that the pictures are blurry and stuff. They are not quite clear, the ones that were provided before he went to the pointings out, and considering that the complexion of the accused as well, he needed a little bit more than just blurry pictures. And y'all do not forget how before even we went into the trial, within a trial, some of the pictures that were submitted by the state were not clear. And the defense counsel always expressed that. You know, even at the time when they were trying to link accused number 3 with pictures, some of them were blurry. Minister was saying that some of these pictures are very blurry. And some of them, they gave them to them in black and white. You know, they didn't give them proper pictures with color in PDF format or in a format that, you know, is clear. You know, just to say that, you know what, how can you conclude that this person did not have injuries from such blurry pictures? Ramosepeli said accused number 1 has testified that he was never taken to Ayrton as police officers allege. They took him straight to Diepkloof, where the assault and tubing continued until he admitted to signing a statement that was given to him by Colonel Mboto. And what is crucial is that he said that when he leaves, he sees Mboto taking the statement to Gininda. That is very crucial because any member of the investigating team, be it Mohula or Mkhani, was not meant to be near where that statement was made. Which is what we heard from Warrant Officer Makubo, you know, and those are the rules. And
you are said to be a mere junior, something.
Those are the rules in the police officers. The investigating officers of that case are not supposed to be anywhere near when that person is making a confession. But what the they are found lurking. They are there, and then you are trying to tell me that those confessions were not gotten under wishy-washy circumstances.
One can argue that
the accused were
they
not
are from
assaulted.
the wishy-washy circumstances, and the problem I have with this, since we're talking about the confessions being admitted, because I'm 110% sure that they are going to be admitted with a long essay of
very
cases
long. Might read for us the
that
whole
are
day.
coming from apartheid time. So you're going to be seeing that, obviously.
Did you see how he was even helped? It was as if that part where Advocate Baloyi was talking about or trying to rebut some of the things that were said in the arguments, how he was being assisted even with cases. You'd swear he was writing it with him or putting it
Sometimes
with
it
him
does
together.
feel like that the judge is really, preparing this thing. It's a feeling that I normally get where they finish each other's work and the way, this and that.
And you could clearly
yes,
see that
yes, the
Advocate Baloyi is
understanding.
not certain about some of the cases, you know. And he's like, yes, that case, wara, that case, so and so and so. Do you know that case? Wara. He squeezes them in. He squeezes them in somehow.
So he's basically submitting all those cases to support the statement that Baloyi made. And he does that a lot.
Yes. It's very disturbing.
It's very disturbing. And it does have that feeling of connection between Baloyi and the judge. And I can't shake it off.
It's troubling.
I mean, you must have known this person that much to be able to finish some of the cases, add some of the things that they are still going to say in the next paragraph or so. I just don't understand. I'm not saying anything.
But it's weird, man. It's very weird. I can't get used to it. It's very weird.
It gives those feeling that I write my stuff, I send them to you, what I'm going to say tomorrow, and then you see, and you're like, okay, sharp, add this, add that.
Yeah, it has that.
It has that
vibe.
feeling. I'm not saying
Yeah.
that that's what happened, but
it's
this is
given. That's
what
what
I
it's
feel.
giving. It has that.
Sometimes
vibe.
I just have that feeling. I don't know. I can't shake it off. But the problem is, this case, if you look at it, in all honest, when Tifo said a trial within a trial must be the initial thing before we go to the main trial. Let us start with a trial within a trial. Now, do you understand why? Do you see why he wanted that? Because for a while we were in a main trial. People were testifying. People were, and with in a trial within a trial, as much as you are not going to bring what happened in a main trial, but you are going to try and align as much as you can. Do you understand?
Yes.
And that is not fair. That is rendering this case unfair. I think at some point this must be made a rule that if there are so-called confessions, we need to start with a trial within a trial if there is a dispute of these confessions admissibility. We must start there before we start going to the main trial, because this gives an advantage to whoever wins this trial within a trial. And I'll tell you, the advantage is going to be with the state, as in my belief is that the state is going to win this. The advantage is going to be with the state. So from here, the state will be leading. I know that they say that this ruling has nothing to do with the judgment.
No, he's trying to justify whatever.
It just doesn't make sense. How can it have nothing to do with? It's a confession. For starters, let me just demonstrate for you. For starters, in that court, what happened is Miss Mapopola, which is Sandi Kumalo, that's a name that we have given them here. Tumi,
Yes.
they went on point blank pointing to Ntanzi.
Accused number 2, yes. In a court.
Now-
they allowed it.
Now I can tell you now. At that point, there was nothing putting Ntanzi in that house.
No.
No accused number 2, accused
No.
number 1.
No.
But from there, they have said it, and they are disputing it, Ntanzi. But if the confessions come and say, at this point in time, we're at so and so that is sort of collaborating the story of Zandi and the confessions. So if confessions are admitted, now they are safely put in that house.
And they'll continue to dispute it.
Hence, Baloyi had to first bring those people who are saying and cry and be hysterical and did what they did. It was before they knew that actually this case is changing now, trying to bring a bit of 375 together, introducing it. The sister is also coming as the mastermind. If you ask me, if you ask them to do it again, you'll get a different reaction, a different story.
What I was also hoping for is, you've just found out from Warrant Officer Makubo that evidence is what is placed before an accused. And depending on what they make of the evidence, that amounts to a confession.
Yes.
Not they go to my workplace and they find out that,
yes.
and then I'm like, I'm tired now. Let me get things off my chest.
Yes.
That's not realistic.
Because you are overwhelmed by the evidence that the state has the SAPS has
Have
collected.
against you.
Now you feel, because you see that evidence, you feel that either way, they're going to catch me. Let me cut myself as like, just say what I need to say and get out of this. Now, that's a different story than having a small chat, nyan, That is still not clear, by the way, because you're still gonna go and look for hoodie and still check if there was a gold tooth and whatnot. So you did not have evidence, and these people made confessions. How it still baffles my mind. How
like
still,
that is what I wish the arguments they would also hammer on, the fact that you claim to have been looking for evidence. You look for this evidence, you go with the accused. By the way, under circumstances that are very dodgy, because for the other cases you initially arrested him for, the matters were not placed on the roll. And
because
some of it was, yeah,
but
hammer
the
on
judge,
that,
look
that
at how,
what is the evidence that you had against the accused?
look at how sneaky this man, for me, this is my opinion, is. He brings the judgment of other cases. He's asking Baloyi, by the way, what happened to that judgment? Baloyi is saying, I think it's accused number 1 was found guilty or something like that.
Yes, it's a Tembisa.
So
court.
you see, he's bringing it.
And we did say that that's
because
what
he wants
do.
to lean on it.
Even though it's
Now-
also very dodgy.
Now here's the question. Upon that search, they stumble upon the ammunition. And
They always
Ntanzi
do that.
was not convicted because there was no warrant of search.
Yes.
What about that? Who's gonna argue for that, judge? If you are balancing the forces here, if you are balancing everything that you do, what you do on the left, you do on the right. Honestly speaking, it seems as if there's only left here, there's no right.
Yeah, pretty much.
Hence, it's easy to see, even if you marinate us towards the end, it's easy to see that you're going to come back with a judgment,
Yeah.
regardless of what you have been told.
Yeah.
Hello? You are going to come with that argument. Regardless of what you've been told, that Ntanzi did not bath, that Ntanzi, that both of them had injuries on the wrist and OBs are not showing that.
That they were taken hours and hours.
That
traveled
they was buying off water that was initially disputed.
that
And
doesn't
Baloyi is
matter,
talking
sure.
about things that were disputed and the contradictions, but he's forgetting those contradictions. What about those contradictions? People said they did not. They later had to explain they bought water. But after debunking that theory that they were even closer to that that proximity of vicinity of what do you call it? Engine
area or the engine garage.
So after a while you get a new theory. Now we are making these people holier than thou because they are police. They refuse some of these things. They until there was AVL.
Yes. Yes.
So with regards to all this that is submitted to you, you still obviously are going to rule that they are admissible because what is this case without these confessions?
There's no case.
What is this case without these
A
confessions?
case without those confessions. There's no going forward. But you can see that the aim here is to go forward and the aim here is to find them guilty, in my opinion and my speculation.
So this trial within a trial, obviously they can position it anywhere. And you will tell me as law people that, yeah, they can do that. And they are allowed, well and good. But I do not think that it favors the defense to do so after leading a lot of witnesses. And then you come and you say, no, now let's go through that issue of trial within a trial. Because Baloyi kept on hammering to say that, no, it's fine, my lord. This evidence is not hammering on the issue of admissibility and whatnot. I'll bring these witnesses. And to think about it, it does have an impact. Some of those witnesses that you call. Those who are from the Spaza house, for example, they have now pointed this man. That's why a normal judge wouldn't have allowed that pointing in that sense.
A normal one.
A normal
we are not
judge.
dealing with a normal judge here. We're dealing with a judge who...
We are dealing with a judge
does
that
things
placed it on
very
record that
differently.
I can see what you did to Buthelezi. That's why I flick. We're dealing with a judge like that.
A judge who can say that.
And what did you do? And the question was going to be simple. If you claim that you saw this is the case, why did you keep quiet, my lord?
Why did you not say anything?
Why did you not say anything
Why?
About it while it was happening?
Why did you not ask Buthelezi himself to find out from himself?
Why do you speak when he's gone?
Why do you talk when he's gone?
If honestly we're talking, obviously we're mixing a bit of a main trial here. I'm just talking about
examples.
A person who's not biased. A person who wants to make sure that the law is actually done and it seems to be done correctly. Was going to stop there and say, look, here's what I need to do. Something, I don't know, do an inquiry, do something. Ask this guy, are you being coerced?
Yes.
I mean, the guy was there for the state, right?
Yes, he was a state witness.
A state witness. And because that guy was there in a main trial, look at it. Was it the main trial or was it there?
Yes, it was the main trial. Buthelezi was
he said Ntanzi looked as if he had not bathed. But Baloyi does not bring that guy because he has said that.
And he was looking down all the time. He said Ntanzi was looking down.
Collaborating Ntanzi's story. And this is someone coming
and
as
Ntanzi
a state witness.
Is telling the court that I was looking down even during the confession with Miss Krunye.
This is where the unfairness of this thing, which is called a trial within a trial.
The same demeanor that Buthelezi was talking about is the same demeanor that
Ntanzi
is describing that I had even with Magistrate Krunye.
So there are a lot of things, and this so-called law, this glorified law, it lacks when it comes to those things. It lacks a lot of things, and there are a lot of things that needs to be changed about this law before we even give it much respect as you guys want us to give those who practice it.
No, it favors the rich. Let us be frank. Let us be honest with the situation. Had these people had money, they wouldn't be sitting.
No, they wouldn't be here.
No, they would not.
But because they don't have money, they are there.
They are using even legal aid. Legal aid even gets to choose for them who gets to represent them.
Yes.
That's the circumstances.
Hence, the questions are being asked when in AKA case, these accused bring one of the top lawyers.
They regarded as the best lawyer.
Where are they getting the money to get this lawyer?
Why do you care?
Why do you care? Because you have a watertight case.
You have a watertight case. Why is that a priority? Why do you care that these people have an expensive lawyer? Don't you have faith in your investigation?
Do you understand? Because you have admitted publicly that these people were arrested in so-called parallel cases.
Yes.
And you made it sound correct. Now you see that they are bringing this type of a lawyer. Now you have to rectify that. You have to find a way of rectifying it. It's not going to be easy.
I'm thinking in my naive self that, okay, you've done the investigations. You have no shadow of a doubt that these people are linked to the crime. Why are you scared of an expensive lawyer? Why do you have to articulate that these people have an expensive... Why are you checking? You are not supposed to be in that position where you question the lawyer because you have a watertight case, right?
So, I do not understand why we have to wait up until Thursday. If you ask me, this man was ready to say something today.
He's now calling it a ruling. It's not a judgment. The Koto Balile is still a long time ago, in
this
my
man
opinion.
Was ready to bring whatever ruling that he has today.
Yes.
Yesterday.
Yes.
It's just a waste of time, if you ask me.
To check all the
That
boxes
is going to come back on Thursday.
and try to convince the masses that...
There's nothing. You have already documented your cases. You even know them by head.
Yes.
It's not that you read them. I mean, there are a lot of cases.
No, he
but
already...
these ones,
yes,
you sound like you have revised them.
Yeah. Yeah.
So you might as well have just said it. And stop keeping us in suspense, as Mnisi said.
Yes. You know how he was upset with Mnisi's statement? It rubbed him off the...
Because it seems as if the ruling is already on the wall.
It's already made.
Let's just get it over and done.
It's already made.
These two guys, I cannot fault them. These two black minds that argued. I cannot fault them. We have been whipping them sometimes there and there.
Yeah.
But when it comes to these heads of argument, I cannot fault them. And I know to some of you, it might feel like they could have done more. There is nothing. The beast they are fighting against is the state. Do you understand?
Yeah.
It's a beast.
Well resourced, well oiled.
The funny thing is that even you in jail, you have paid for that.
Yeah.
Like people like Bontans who were working innocent
Tax
jobs.
money.
They were paying for that.
You know, and also that I can't get over that condescending tone when he's saying that accused number 2 spoke big English when he said he certified documents. And
I wish in that line, I wish they could have asked him, Your Lordship, perhaps you can clarify, or anyone who knows Zulu here, what is to certify in Zulu? What is to certify in Zulu? What do you call it?
You know, that troubled me. That troubled my spirit. I'm like, this person that you have detained here and you're busy, condescending, had a job.
I can tell you now.
Where in this country do you get the job without certifying documents?
I can tell you now. If you were to explain certify in Zulu, it's not going to be one word.
No, because it's not there. It has to be kind of made, right?
Do you understand?
Yes, it has to be made because it's a term that came recently. It's
Exactly.
not as old as the Zulu language.
To certify in Zulu, ukudlulisa ingcukaca emthombeni ethembekile.
A full sentence.
Yayizwa lento le?
It's a
That
full
is
sentence.
that is now a deep Zulu. Udlulisa ingcukaca emthombeni ethembekile. That's how it is.
I'm just over, like, I was so bored with that statement that he made. I'm like, what is the reason? Why do you want to make accused number 2 feel so uncomfortable for merely having a job? In this country, you have to certify documents. You cannot get opportunities without certifying documents. It's a prerequisite. So he had a job. Of course, he was certifying documents every now and again. And he said, I went to Pukeng because that's where I certified documents. You understand what I'm saying? And now you try to use this against him because you want him to look like a liar for saying that he could not speak English. You want to use something that he does on a daily basis to say that he has no right to be asking for an interpreter now in this court. He has no right to be asking to be explained in Zulu that what am I doing, what am I signing, because he knows the word certify.
Honestly speaking,
That
Uzenza,
sounds stupid.
he's pretending as if he's a master of Zulu, but he does not know Zulu. And the funny thing is, we have such weights as this ones. So if there was a one weight for it, but for now, if you were to ask me, ukudlulisa ingcukaca emthombeni ethembekile ukuze zihlolwe.
It's a full sentence.
Yayizwa lonto le ukuchaza the whole thing.
Even I, in Setswana, I'm trying to think, what is certifying? I'm trying to think. I don't know.
He's
I would
busy.
probably say, who isa dipampiri gore ba di sign, who isa dipampiri gore ba di netefatse gore ke tsona dipampiri tseo ke tsa gago. It's a full sentence.
Befake isigxivizo ezulwini.
Wait.
Ngoba istamp isigxivizo.
It's a full sentence. There's
So
no
you can't just come with one word of that thing as if it's existing, it's somewhere.
What is engine garage in isiZulu?
Ayikho into enjalo.
I don't like where this is going. Like you literally feel
it is just
you literally feel it that this man has made up his mind already.
It is just sickening to watch. You are correct. It is sickening to watch because he's pretending as if there's some weight for these things and he's using it.
I don't understand what I'm watching. Like, I don't get it. Well, Ramosepeli said, I submitted would be pure speculation in the absence of a J88 for us to know how he was kicked. Because at this time around, he was pointing out that not only the plastic suffocation was happening, but as well as he claims, the accused number one claims that he was kicked by 13 police officers. He said that he was kicked by 13 police officers, so Ratha wants to see evidence of that. Netefatsa eng? Because o ka netefatsa eng? You have to be specific. Certify. What do you mean certify?
Certify anything, but at least you guys maybe
at least you have a word.
It has one weight.
Netefatsa, make valid. You know. That could be a word.
Yo, you have to borrow that book called Ngoloban and maybe
and try to come up with a word.
Yeah.
Yo, I felt it. I was like, yo, he's so nole. But anyway, with regards to the whole 13 kicking, he said there was some time way back, a couple of weeks ago, where he was saying that he was even kicked with boots. So he's expecting accused number one to have evidence of being kicked.
That's how crazy this law was. Because it was made at a time where people were kicked.
And the very same people that were kicking him were expected to take him to a medical doctor so that he can be checked whether he was kicked or not. When I say the very same people, I mean the police. The police are the ones who arrested him. The very same police are the ones who are supposed to take him to the doctor to see whether he was assaulted or not.
And then they bring these so-called people who were signing OBs and whatnot. They bring 4 of them.
No, they were not even brought because
they bring 2 of them.
We got names and turns out there from Pukeng today. We found out. We're the ones
out
from
of
Johannesburg
all
and Pretoria.
These police stations where these people were transferred to, out of all these places, you bring 2, you bring 4.
Where are the other 2?
He said actually it's 4.
He said it's 4.
Hey.
And he said that the other 2 testified.
Something like that, something to that effect. This guy is a defense. I mean, is an NPA
prosecutor
person.
He's a prosecutor.
He's just
as a judge.
Man, he's just. It just doesn't make sense how you can be this negative to other minds if we are not biased.
No, he is biased. It is what it is. Maybe he's doing it on purpose or what, I don't understand, but he is clearly biased.
It just doesn't make sense. I mean, honestly speaking, I can try to defend him if this is how he works. With you see, the thing is, Baloyi can for many years doing that, but the defense does that. Okay, we understand. What more? What more do you want?
The whole day.
And then you tell me that person wants to see justice.
We don't have the whole day. What's your point?
For others, he's got time and is more awake.
He even assists them.
You know, others is writing a lot. Then others is busy. He wants them to be fast. In fact, to even write, it seems as if he's forced now to seem like he's writing.
Well, yeah, Ramosepeli did say that it would be pure speculation in the absence of a J88 for them to know how he was kicked, accused number one. So then Ramosepeli said, accused number one said that he was never taken to Ayrton as the police allege, but straight to Diepkloof police station where the assaults continued and he was forced to sign that statement. And another thing that's very interesting is this Vusimusi hostel. This Vusimusi hostel does not exist.
And I know people are saying we are not disputing that there is a hostel.
There is a hostel.
In Vusimusi
section.
But is it called Vusimusi hostel? No. It's like having a school in Randburg. Is it called Randburg High School? No. It is just there, situated in Randburg. Or it's there, situated in Durban.
It has its own name.
It has its own name.
So police are particular when it comes to addresses, but somehow these ones are not. You would have known the right name of that hostel. Akiri, you're investigating. You're an investigating officer. Provided that you also found people at the gate, they would have given you the correct name of that hostel.
And provided that you had a pocketbook that you were writing all these processes.
Yes.
You could have written all these processes on, and it will be easier for you to remember even if you have forgotten. But no, you guys don't bring that up. You guys are the top
Let's
dogs.
not forget that they were also enforcing an incorrect address of 818.
And it's okay. Water under the bridge. It's done.
They said they verified it. They went with him to his place of residence, and what they
For
saw
that reason
was
in particular.
818.
Other than the first explanation of an ID, that is accused number one we're talking about. They went there later when they are probed. They changed. No, it's not ID. We wanted to verify the address because we got him at the shop. So we wanted to verify where he stays.
But yet accused...
That does not count as accused number one has one theory.
That doesn't change.
Because your theory has changed many times. That's not going to count.
No, that's not going to count. And it's consistent because even with this confession process, he's saying these people had my ID. Accused number one said they had my ID. He was feeling things and he had my ID. With Miss Muzi and Ntanzi saying she had my ID over there. She was feeling and she had my ID. Where did they get the IDs? Why are they not telling us that they took the IDs?
And how they entered that house. This is where you see the differences and the powers at play, if you ask me. They go to accused number one's room. They stumble upon ammunition. Right?
Right.
The same way they did to Ntanzi. No warrant of search. They got accused number one away from the house. It was not closer to that vicinity, right? So there was no need for them to do that search that they did, right?
Yes.
But
they still went in.
And let's not forget, this happened also to accused number 3. They got accused number 3 outside their house.
Yes.
From fetching the girlfriend.
Yes, yes.
But they went with him inside the house, and that's how the gun was found. Right? Now, this is where the difference is. Is that Puken magistrate that exonerated Ntanzi?
Yes.
Yes. Puken magistrate exonerated Ntanzi on the basis that there was no warrant of search there. The Tembisa magistrate, is that the Tembisa magistrate? Yes, the Tembisa magistrate.
Yes. The one for accused number one's case.
It handed the judgment. And the judgment is one that part of the reason why that accused number one is there.
Yes.
Right?
Yes.
This is where you see the differences in applying these laws. Same group of people, maybe few different.
And the very same judge was saying that there's a way that they can get in without a search warrant. He was defending that. He was defending that the judge at Pukeng does not know the law. They were supposed to...
it was the same way
continue with this case.
It was the same way we explained why and how these people can have a warrant of search. Enter your house without the warrant of search. It's in the case of emergency, and if they can really prove that this was a case of emergency, then they can get in your house. For example,
but that's not how
you have someone,
the judge put it.
You are holding someone at ransom in your house. You know, you want whatever you want. You are shouting. There, they don't need a warrant of search.
No,
you have invited them because they need to protect that person.
Yes,
but arresting a person outside, far from the shop,
back home.
You take him back.
Then you
home.
Search.
And then you claim that you went there to verify the address.
Aibo. And you know what? The another awkward thing about this is that they left accused number 2 in the car. They went and they
claimed they didn't. They claimed they didn't. He was arguing.
According to his version.
He was arguing. The judge is arguing. Already you can tell the judge was arguing that they say their version is not that. Their version is not that. What is Ramosepeli supposed to put their version and forget his customer's version?
Why must Ramosepeli think about the version of the police? He's not representing the police. He's representing accused number 2.
This man
Why
would
must he
fight
not
you
put the version of his client?
If you intentionally forget the version of the police, he will fight you. You must put everything on record. But Baloyi can come and say, "This is the case, my lord. This is what they are saying, my lord." It's okay with Baloyi. It's okay. He must not put everything on record. But the defense must bear the burden of remembering what these people are saying and say it.
This is kind of embarrassing.
For his liking, I don't know. It's like he wants to hear this like a coding thing. If it's repeated many times, even if however it is repeated, then it becomes true.
You know what's worrying me about this case and it being so global and the world is watching? Can you think of all the opportunists in the world?
They are watching.
They're thinking, if I come to South Africa and I have money, anything is possible.
Yeah, and indeed, we can safely say that anything is possible if you have money. This is South Africa. That's how things are.
It's scary, man. It's scary. I feel so unsafe.
Oh, we've long been naked.
We are exposed. It's not even funny. Kore, he's not thinking about that. I'm seeing he's refined to thinking of Kurleni, thinking of the country. The world is watching your conduct, Judge.
No,
they are watching.
I think we've gone past that thing of thinking about himself, about what people are saying. In my opinion,
yeah, we are beyond that.
We are beyond that. We are at a stage where he's gonna want to prove and try to use this law. Basically, what he's proving, the judge, for me, what the judge is proving is that you can maneuver around these laws. You can mix cases, old cases. Is there no system where old cases, because you cannot throw them out, they could have just been put in a certain test if they still stand in a democratic country? Do you understand? And then those cases that pass that test, then they are used as a reference.
Yes.
Those that did not pass that test,
leave them.
Throw them out. Don't even when you are referencing them in court, they should tell you that is not going to assist your case.
True.
That I don't know.
I feel like we need that adjustment.
I think that's what was supposed to happen.
There's too much crisscross with that system that was very much unfair on not only a person of color, but a person who had no money as well.
And this man, which makes me wonder, what was he doing when our grannies were busy? Because he knows them all. Not to say that he's, obviously we know that they read, but
I don't even want to think that far.
I mean, he can bring them all.
Hey, I don't want to think that far.
No, we have to, because I mean, if you ask
Kodwa
me,
kuyathusa.
he's mostly relying on those cases. I know he's old, but there are new cases, most.
There are new cases. Ziningi nqaba, too many new cases. All the way back from, let's say, 2000. There's so many cases that have taken place. And I have seen him cringe at the mention of some cases. You know, there was a time that Mngomezulu quoted a case. I think there's one that was ruled in KZN or something. His body language, man, it was like, I don't think he agrees with this one. But it is what it is. He will quote the ones, obviously, from pre-1994. Those are the ones that are his favorite. But when it comes to these newer ones and fresher ones, the way he selects them, it's like, okay, aren't there others that are counter-arguing these ones, you know? But I guess that the onus is on the defense as well to dig deeper when it comes to these cases and really try to understand.
What deeper can you dig? If those cases are accepted, then what can you do?
There's nothing you can do.
Because, I mean, they will always find a way of
squeezing
them in. It's like, I don't want to make an example of this, but I'll use maybe something else. Like, basically, you are doomed if you use them. You are doomed if you don't use them.
So the first argument he brought up, Ramosepeli, was that he said that accused number one, okay, this is the judge now, after the tea adjournment. He was addressing the whole situation where accused number one has decided to take the service of Mngomezulu instead of Ramosepeli. And he was using the term that he fired him. You know, and why is he was questioning Ramosepeli as to why he's making submissions on behalf of accused number one.
Yeah.
The judge asked what must he make of those submissions. And since they said that they were defending these guys as a team, you know, Ramosepeli said that he will leave it in the hands of the court because he has already started the process and he was never told. And I think they made the submission with Mngomezulu to say they are going to continue. Because Mngomezulu was the one who was doing the cross-examination. Ramosepeli did not do the cross-examinations.
In fact, you can go as far as back on Friday. Ramosepeli says, I'm going to go and prepare, but try to reduce what I was going to say on the basis that Mngomezulu has submitted some of the things. So, there is not told to Chief, prepare for your person.
No.
It's not told.
In fact, they were happy to hear that because they're like, ooh, less time or something. They received that. You know, it was not a problem, was not an issue. Well, the judge said that it was easier for Mr. Mngomezulu to do that because Mr. Mngomezulu, said that he was not paid. But for Mr. Ramosepeli, it's different. He said the reason is you are fired. Rubbing it in Mtakabao, putting it as if it's this horrible, horrendous thing that has just happened. Ramosepeli responded by saying that I'm unfireable, my lord. What did you think of that situation? That I'm unfireable.
Look, I don't even know whether unfireable exists, but that's one way of fending this man off.
Hey.
So that you can continue with what you need to stand. You create now a joke like him. Navigate out of the situation. I guess you did that well. So I don't blame him. What can you do? This man has many ways, many tricks of making you lose the direction of where you're going, if you ask me. I see. And we look, I mean, you know the funny thing. The funny thing is that when Baloyi finished his heads of argument, in the very same place where we are, I said, just watch and see what he's going to do to the defense. You see how he was quiet with Baloyi, and in fact helping him even finishing each other's
2
sentences.
whole days of peace.
Watch how he's going to be irritated with the defense.
Oh, he was very much. He did not disappoint.
Has he disappointed me?
No.
No.
He did not disappoint at all. Well, I also heard the judge asking if accused number 1 understood the consequences of impending a signature. Ramosepeli said that accused number 2 can only write in Zulu. That's actually accused number 1 can only write in Zulu, although he can sign an initial. However, the police would just tell him, sign here, because that's what the police do, honestly speaking. They just say sign. Then you sign, especially if you are getting in that situation for the very first time and you are not understanding of the process. You will sign because you are feeling scared and you are feeling all kinds of weirdness.
Even the unfairness in this world, even your contracts.
Yeah.
That's
it's not
how
like
you
you will
sign
get
them.
the job if you don't sign.
You understand? That's how you sign them.
It's not like you
for
say,
those
I
who are
don't
not
want to sign.
like for those who are not educated, that's how they sign them. For those who can negotiate, and some who are educated, by the way, let us put it in record that some who are educated, that's how they sign their forms, because they tell you either way we are not changing this.
You still sign. What choice do you have? You're thinking this opportunity will surpass me. Must it go because now I have conditions, especially coming from us people of color.
We
you
don't
have a choice. You
We
want
have
to
less
survive.
conditions.
You want a salary. You want, to live. There's no time to be negotiating when you're coming from poverty, So you just want to get your life right. And then that's how we end up in the messes that we end up in. Even with the music business, even with the everywhere, even in the employment situations, you find yourself being exploited and what. To go to the doctor when they were incarcerated, and the very same people that incarcerated them had control of their movements. How is that supposed to happen? I don't understand. So the judge said that even with accused number 2, he said the word certify. I've already addressed this where he was mocking how he thought that he spoke good English or better English. He said that's what it is. And I had a problem with it. I still do.
We are buffering a bit. Emily, someone says we must pause a bit and wait for likes. If we get them, then we continue. What do you say?
The likes do help. We appreciate them a lot. The likes help. So we would like for you guys to press the like button. Please.
Yeah, can you please
we are
have the
begging you
likes,
for
guys?
the likes. Press that like button, Mtagama. Press it. Press it so that we are all okay. I mean,
so we always rely on the morning.
We don't have what would I say, Mr. Anonymous? We don't have like what do we call it, a marketing what team or the like button for us is what does the work of getting to reach people who may now, for instance, be offline. You don't want them to miss the video. So
I think we all understand that.
yeah, with the like button,
can
it
you please have
helps
the like?
reach the people that are
It's a
subscribed
request,
and are not watching.
It's a request that is very painful because you have to request regardless. No matter how umuntu uzomthola abukile nje into content yakho, but you have to request. So we are requesting for the likes, guys.
With respect.
And we trust the morning gang. Obviously, they take us to 1,000 or something
and
or so.
over. Yeah, the morning gang is the best.
The morning
guys.
gang is the best when it comes to liking. They even pride themselves with that. So please, guys, can we have the likes? Yeah, I mean, you can continue. I see they are growing a bit.
Yeah, thank you guys. Thank you. Highly appreciated. Ramosepeli went on to discuss the photos that were taken by Sergeant Mapakela of the pre-pointing out. He said that they were informed that the purpose was to show that in future, should allegations of assault take place, the photos were taken for the purposes of saying that there were no assaults. Ramosepeli said that he is submitting that those photos are of poor quality for the purposes of which they were taken. They are too grainy, too far. There are no close-ups of the body to show whether there are any bruises or any cuts. With the dark skin of accused number one, it makes it difficult without close-ups to see any bruises. The judge asked if that is the same sentiment carried by Mr. Baloyi, that the photographs are useless. Look at how he makes it climb a mountain. They are
so that
useless.
Baloyi can react. Sometimes it's like a signal. He does not want to say it himself that I do not take what you are saying. I want Baloyi. What do you say? Hello? Hello? Hello, Baloyi?
It's like he instigates. He instigates a reaction out of Baloyi that he wants, actually. Yeah, and I also don't know why Mr. Baloyi, in my opinion, had to be inserted in Mr. Ramosepeli's argument, like being asked what he thinks, being asked why.
In no way or form of shape where Baloyi was arguing and the judge
who asked the defense or what they think. Asked Ramosepeli in particular what he thought.
They were just talking to each other.
It's very weird. And we are expected to overlook all of this and act like it's not happening. It's happening, guys. It's happening. It's happening. Hello?
Baloyi? Hello? Ramosepeli, Lamsapar. Baloyi? Hello?
Ramosepeli and Hashem. He has no respect for him. Baloyi then said Sergeant Mapakela testified and it was never put to him. The judge laughed, Remember how I was telling you guys about Ramosepeli many months ago, about him always saying that I will leave this for argument. I will leave this for argument without really putting it to the witness. Now that is catching up with him, in my opinion.
No. You can't even blame that.
I shouldn't. I feel like some of the things
when it's a lawyer thing, it's a law thing. When the
witnesses were there testifying, you must put all of these things to them.
No. Lawyers are undermined in higher courts if you are an attorney. And it depends on what kind of an attorney are you. Are you a shark? Okay. Or if you are not a shark, obviously these people undermine each other, man.
True.
They undermine each other. I think Ramosepeli is one of those. They just looked at him. They were like in their head how he's actually putting his things. And then when he was found in Tata sometimes during the trial, didn't try it.
For argument.
And then they're like, this one is a weak link. And that's how they felt. Today, he was putting that face, a stern face, and then it was a problem with the judge.
Yeah, he was upset.
Yeah.
He was.
Because if you feel the backing of the big sharks, such as Mngomezulu and everyone else around you, now and then whispering in your ear, you feel that energy and you also start wearing the same energy as they were wearing. So that's what was happening. And he pushed properly. And obviously, Ramosepeli is also a seasoned lawyer. Just that, this is High Court. Mm-hmm. They have that thing.
Okay, I'll take your submission. Ramosepeli said that other point was raised by his learned colleague was that accused number one on the pro forma made certain corrections to say that he was not swayed or to show that the officer was. He said that in his examination of Colonel Mboto, he asked him whether he familiarized or asked accused number one of his highest standard at school. He said that he told me that he did lower level. I don't want to embarrass him. So he practically does not have serious formal education. Ramosepeli said that his submission is, how can somebody of that low level of education make corrections on a semi-statutory form that is written in legalese, not English, legalese, legal term language. The judge asked, are you saying it's impossible?
Without a
Ramosepeli
person
said,
who's actually translating, yes.
Ramosepeli said, it is, my lord. And the judge said, I know we had a president who only had standard 4. Ramosepeli said, that's a very good example. He's got reports with other presidents and dignitaries. You learn on the job. He learned on the job, his job as well. Okay, not
And you are talking about, by the way, that same president you are talking about, you are talking about someone who went to exile.
We're talking about someone who
And
was
there,
in the military.
they explained, they were reading, because they had to read what is happening in South Africa.
Yes.
They were doing all these other things. They can speak English.
They were writing letters.
They were writing letters. Not that you would know, maybe, because, I mean,
When I'm only busy,
no busy, you were studying. Just say,
let me hold my tongue.
oh, you are studying. The studies of...
And not
doing that.
only did he have standard 4 education, he also had military training. Okay, he joined Mkhonto.
And that was when it was still the ish. They
exactly.
would teach you certain things.
And they were in foreign countries and they were communicating in English over there most of the time. So the life experience of the former president being compared to the life experience of Sibiya, who's never even left the country, who's never probably communicated with letters because of the era that we're in with
He's
cell
from
phones and social media.
villages in KZN. Villages where you look after kettles, you shiling goma. That's it.
And you want to
You
compare
only
him.
speak to people who speak your language.
You want to compare him to the life experience. Oh my gosh, guys.
In fact, I feel like they undermine also the former
The president as well.
Unfortunately,
Ow.
it does
No,
feel like
no,
that
no.
sometimes.
And he said, the judge, he ran the country for 2 terms, and then he was also an MP, Minister for Economic Affairs in KwaZulu-Natal, etc., etc. I can quote 2 or 3 guys in the cabinet who are just like that. Him running the country for 2 terms, in my opinion, dependent on his ability to speak English. Okay, but as well, not only the ability to speak English, the people put him there. There are this thing called votes.
Like,
It has
I
nothing
wonder
to
if
do
we were to put
with
votes
his level of
for
English.
Ratha and say, Ratha, you depend on South African people as they are watching this case for you to stand and sit here. How many votes you'd probably get? Now, I'm just wondering.
Not much. Not much. Not much. And maybe that's the privilege that comes with being in a position where it's not reliant on people for you to be placed there.
And
Because
the
you
pity
would- you
about
would-
this work,
You would do
it
the
touches
job
people.
differently.
It touches people.
It affects people's
It
lives.
affects people's life
Sending
forever.
someone to prison, you
It's
have
more
to
like-
make sure that that person really did do the crime.
Yeah, it's more like killing that person sometimes.
Because
it
not
can
only
be
the
equivalent
person,
to
the
killing
family
and the
as well,
family.
the children that are supposed to grow up with their father present, they no longer have that privilege and
I
opportunity.
have no problem with people who are arrested and they are supposed to be there. No problem
No.
whatsoever.
Yes, the ones who did the
Now,
crime.
the issue of whether you are harsh or
If
not
it's
harsh,
proven beyond reasonable doubt, they do the crime.
that reasonable
I
doubt, I
have-
no longer use it.
Yes.
I no longer use it. In this South African court, reasonable doubt, it
I
means that
I
you have
exist.
followed everything. Whether it's wrong or right, it does not matter.
I exist well in South Africa. I don't think much of reasonable doubt. They don't even use it. They don't even use it in court.
Do you think the state has proven beyond reasonable
No.
doubt that this?
No.
They haven't. In
No, they
fact,
have
in some
not.
of their testimony, they have admitted to some of the things that these people are saying.
Yes.
Can those things be used? No.
No.
One person took a statement, recording. I'm talking about someone who's supposed to apply these laws. Someone who one day is supposed to say it is wrong to record someone.
They were
without their awareness. It is wrong.
It had to be hammered.
A person did that.
They were willing to not even follow the Constitution. They had to be reminded with force that the Constitution says recording someone without their permission is illegal.
We are talking about someone who sits and listens to things like that being submitted. What do you think that person does?
Yo.
That thing was not even supposed to see
the judgment.
That thing was not even supposed to see the day in court. It was not even supposed to come from the judge's point of view. We were supposed to hide it for herself.
How did it even come out baffles me.
The fact that you are willing to use it. The
boldness to even use it in a court, and you are a magistrate and you clearly violated the Constitution and you are using it with so much bravery and
yeah, bro.
Yeah. Ramosepeli said, I'm not casting any aspersions to my client. And the judge said, even me, I'm not. I'm just saying that this notion of saying if you haven't gone to reside ABCD, then you are not educated.
And you tell me that this man was a good lawyer.
No.
He's making a point.
Oh, you mean Ramosepeli?
Yeah, he's trying to make a point, right?
Yes, he's trying to make a point.
And the point was that you can actually have education. You can actually know some of these things without going to school.
Yes, he said
but
that.
But because of how it was put, if I was a judge, I would be irritated.
Well, Ramosepeli said that there is a difference between education and cleverness. Or smartness.
We're talking about someone who, at some point, was part of the head of the intelligence.
Intelligence, bathong, helang. We forget. He was head of intelligence.
And then you make examples like that.
And you compare him to Sbiawa Bantu. Oh, Nkosi yami.
I wonder if you would have survived when running away from people without them seeing you while we are amongst them sometimes. It's a question for clever blacks.
Well, the judge said, what did they call it? The guys who want to bring about the Africanization of knowledge and education, the indigenization of knowledge. Guys, this thing bothers him so much. He always brings it up. What's the beef with people that want to Africanize the system?
There's a friend of mine that I know, and I'm making it's an example, but it's a reality. What I have noticed about her is that she gets her money through, being affiliated with men who's got money, and they give their money after whatever time that they had with her. Mm-hmm. She posts about that. Okay. A lot. She posts about the money she's getting. She justifies it. So where I'm going with this is that if you feel that your education, you got it in a certain way that is maybe difficult, or you feel you need to protect it. We got it in a country where freedom was there at the time, the so-called freedom. We are okay with it. We can criticize it.
Yes.
Because we're not told to say that this education is the best thing that we have ever had. But we know that we are educated so that we can put bread on our tables. That's it.
That's it.
And it ends there.
And also,
once you find yourself trying to justify a certain thing, a certain system, you must know that it was enforced to you. You had to porridge someone's feet for you to get there. I'm just saying it.
Yeah, you had to do a lot.
So some of us didn't have to do that. Luckily, the uneducated president said, you guys will study for free. And I'm that class. Even though there were sponsors, but I'm that class.
Well, Ramosepeli said, especially in relation to the Western Cape Court, where the forensic terms were difficult even for the interpreter, Ramosepeli said that he was instructed to just make initials next to wherever they were marking. So the judge says, so you are saying that accused number 1 can't write and can't read. Oh my goodness. Ramosepeli said accused number 2 was arrested by Sergeant Mabena and Mokhani. He was being sought for the Nongoma case. The assault started there when accused number 2 asked them, you asked for my name and I have given it to you, my ID and phones, who are you? He states that Sergeant Mabena hit him with an open hand across the face, telling him not to be smart. From there, he said, I submit the line on the set when it comes to the treatment of accused number 2 was set. Ramosepeli argued that the treatment that accused number 2 got during his arrest was the beginning of what was to come. And he was transported from Rustenburg to the Pretoria North Police Station on the 16th of June, and he arrived there shortly after 10 o'clock at night. The judge asked why he says a marker was set. Was Mabena not a frolic of his own? So now he's a frolic of his own. He's not a part of the police.
Hey, the judge lady.
He said, you are saying that with the alleged slapping of accused number 2, then a line is drawn on the sand that he's going to be treated with assault. Ramosepeli said, especially pertaining to Mabena, because he is the central to all the assaults that were perpetrated against the accused. And the judge said, yeah, but he died thereafter. He died. Ramosepeli asked the judge if he died after the 16th of June. And the judge said, after the assault. And then he let it go. It was cringy. Guys, it was very cringy.
No, we had to ask that question.
But we moved.
So now that he passed away, we're not supposed to say that he slapped someone.
Mm-hmm. But then he the way he was saying he died, I'm like,
what, did you think that he should have said it in a nicer way?
I don't know what I was thinking or expecting, but
I didn't even notice it. I'm sorry, I did not notice it. I did not notice it.
Who on
I
expectations?
remember what Ntanzi said. Unkulunkulu ambusise.
Okay.
Yeah, ngati.
Yeah, Ramosepeli now turned to argue on behalf of accused number 2, Bongani Ntanzi, and Ramosepeli described the arrest of accused number 2 at Phokeng. You know, yeah. Although I have to admit, he kept saying accused number 1, accused number 2, but I know who he was talking about, so let's continue. Ramosepeli said the events on the 17th of June, there was no assault, it was just interviews and allegations regarding the gold teeth, dreadlocks, and the tattoos. Then on the 18th of June, accused was booked and taken to Carlton Villa Sibanye Stillwater Mine, where he was employed previously in around 2015-2016. He was transported by Mokhane and Mabena to do the investigations at shaft number 8. They get records and history of accused number 2, and at a certain stage, Gininda arrives at the company of Mohola. The discussion is held amongst themselves to go to the hospital section to see whether accused number 1 had reported injuries in and around the 26th of October 2014. So certain documentation, whether medical or otherwise, were handed to him. The defense was not privy to those documentation, he emphasized. Then Gininda went to the car. Accused number 2 was kept in the Toyota Fortuner. Then he starts questioning and interrogating accused number 2 about his possible involvement in the Senzo Meyiwa murder case. And accused number 2 is steadfast that he doesn't know anything about it. He's even confronted by evidence that emanates from the main case, the ID kit. He says that this is mistaken identity, seeing that his head is against the rock. Brigadier Gininda stopped questioning accused number 2. As he's leaving the motor vehicle, he says one of the officers that he was with, that he has never identified in this court, calls him to say that accused number 2 wants to speak to you. Then he goes back to the car and warns him about his constitutional rights and says, let me hear what you are saying. Why did you call me? Accused number 2 says, the lies don't work for me. I want to tell the truth. which is vehemently denied by accused number 2. That assertion by Gininda saying having tried by all means to elicit information or some sort of admission from accused number 2 and having failed, what are the probabilities that accused number 2 has successfully rebuffed any allegations to link him to this horrific incident? Accused number 2 now tell him to come back. Lies don't work for me. I want to tell the truth. Ramosepeli said we submit that the probabilities don't favor him on that aspect. The judge said, yes, I hear you, but that is disputed evidence. Gininda does not entertain the version. Why does it matter whether Gininda entertains the version or not? Is this not a court of law? Or is this the court of Gininda? What is going on? Why does it matter that much to the judge that he disputed it? I think this is where I appreciate judges who and only ask important things, who don't interrupt arguments when they are being made.
And become part of the case, like
I appreciate them.
Part
now.
of the defense, back and forth.
Because they don't give me this privilege of
you know,
this.
Other judges, when they say, but sir, what do you say of 1, 2, 3? You know, putting the certain theory, you can see that they are sussing you out. Also part of, did you even look at the book? Do you understand what you're talking about? And also maybe clarify some of the things to make them see them the other way. And then this one on the other side, the clarity is not as the clarity for me. It's like this person wants to be part of this thing, like he's debating with you. It's not even
hostile, man.
You can even lose your direction of what you wanted to argue on. You end up finding yourself having to discuss and put an opinion on indigenous learning or something like that. I mean, honestly speaking, where does that, while someone is busy with his heads of argument?
Well, Ramosepeli had to point it out that we have seen on the stand the memory of Gininda to show that this assertion does not have any substance. He was with at least 3 officers, Mabena, Mokhani, Mokhula, but he does not recall of the 3 who called him to say that accused number 2 wants to speak to him. Accused number 2 vehemently denied making any confession statement to Brigadier Gininda.
Yes.
And Ramosepeli said, according to the AVL report, the Toyota Fortuner was at the mine complex for a period of 7 hours. That period is crucial when it comes to what we term as the torture of accused number 2. Accused number 2 was asked whether when he was booked in the morning to have anything to eat for breakfast, he said he never did. And there's no evidence before this court that in those 7 hours accused number 2 was given food or water. But the critical question is, did all those guys, Mohola and Mabena, did they eat? Asked the judge.
It does not matter.
Why
we are
does
talking
it
about
matter?
someone who's arrested.
Why does it matter?
We are talking about, we don't care about
They
people
have
who
guts.
choose not to eat. If they are fasting, if they had to fast for their churches,
They are
or whatsoever,
not in
where
handcuffs and
does
incarcerated.
no one is stopping them from doing what they need to do?
It's not like they were in jail. It's not like they had handcuffs on and they were being transported from pillar to post. They were the ones doing it. They passed stores and supermarkets and whatnot. They had the liberty of such.
It does not matter.
And why should it matter? This case is not about them. It's about the accused.
If me I'm fasting, then that's me.
Ramosepeli then said, my point is this: according to the act that governs prison guards, there are certain periods where the accused must be fed. They are in the field, he said to the judge, Mr. Ramosepeli.
Even when they are in the field.
In Carltonville. According to Ratha, Carltonville is a field. And he said, on probabilities, did Mabena or Mohola eat for 7 hours? They didn't even drink water.
Right.
Yeah. Ramosepeli said, I will be misleading the court if I give an answer. No evidence was led. I can't venture into that speculation. I heard Ratha yawn after this. I don't know whether it was a funny sound or whatever, but it was an irritating sound in my opinion after such a comeback from Ramosepeli. You understand? Ramosepeli moved to the part where Gininda and team went to Ntanzi's HR. The judge asked what they were doing when they preoccupied with the investigation, whether they were just wasting time or playing cards or drinking alcohol in those 7 hours. So was it 7 hours? But it was a long time when they did go to the HR as well. Ramosepeli said, all I know is that they went to HR, they waited and spoke to Colonel Gininda, then Colonel Gininda became part of whatever investigation was being conducted, going to the hospital section. The judge reminded him that they also went to the hospital, and he further said that they drove there, basically
trying to
justify,
fill up the 7 hours, eh?
Yes, justify the 7 hours.
Fill it up, man. It's not full yet. You need to remember this. Oh, please. It's evidence. Oh, hello?
He
Please,
then
it's
asked,
evidence.
he then asked, just as an afterthought, are police allowed to, in terms of the law, not on a whim of their own, in terms of the law, to investigate for 48 hours, depending on the exigency of the case, or they come to a stage when it's time to sleep? Does it reach a point lapho isikhathi sokulala?
Overtime. Does it reach a point of overtime? In times of emergency, they cannot sleep. They cannot sleep while we are fighting, for example, with other countries. They cannot sleep.
Ramosepeli said that he did not print it, but he went over 2 national instructions over the weekend, and it says in between interrogations, between 48 hours, every 24 hours, an accused person per every 24 hours must be given 8 hours of rest. And he said he will get it for the court. So Ramosepeli is saying that he was reading somewhere, and he said that as you are being incarcerated or captured or arrested, 8 hours within the 24 hours you must get your 8 hours.
Sinenhlanhla saying JP Mlambo needs to do something about that.
That shape has sunk. that hope is no longer there. It was crushed. The judge said, as a matter of common sense, the police will tell you that they have dispersed a squad. Our police minister normally would say who are going to cross night or go around the clock looking for Ratha and his gang until they find him. He was making an example about the minister of police whenever there's a serious crime and that media thing he does, and he says police are working around the clock, they're cross-nighting until they find whatever they're looking for. So Ramosepeli said that being locked in the cells has certain benefits to the arrested person. They get fed, they get to stretch their legs, handcuffs are removed, and they can lay down. Mohane said that he was going to be bored. The judge asked what was supposed to happen to him. Where is he supposed to be? Ramosepeli said that he was supposed to be locked in the cells and they can go in and do their own investigations because he is now in handcuffs from morning around 8 a.m. all the way up until midnight. And the judge doesn't think that is torture. Ramosepeli argued that Ntanzi should have been taken to the cells to rest after the investigations at his place of employment. The notion that he would be bored in the cells borders along the lines of ludicrous. And I agree with the statement. He is a high-profile target according to the language that is used by police who are, after his trip from Carltonville, required an escort from EMPD. He's accused of this heinous crime, yet the police take him without escort on their own frolic to Alberton. and law, and behold, when they get to Alberton, they forget that AVL will come and say that they were in Alberton at a garage. And according to a submission, accused number 2 was assaulted at that place. That was the purpose, These issues that he was going to be bored and standing orders are clear. Accused persons must, as soon as possible, be returned to the cells to be held there. They are stuck from around 6 p.m. and the car leaves the engine, Moody Street, in that area around 12:09 midnight. In that period, there are police stations around Germiston, Boksburg, Alberton that they could easily have used because of the threat and the target that they have, or the person that is accused that is in their custody, Now, whatever the police station in the south, they could have found and then put him there until the car is repaired. Or in an alternative, now that Jonathan and the other escorts came in, somebody could have guarded the stricken Toyota Fortuner. And as a matter of fact, agency accused number 2 is taken to one of the safety cars back to the cells. And before he could finish, the judge said that in hindsight, he is correct. He made an example that instead of them calling a police station in Nongoma and asked them to go and check the school where accused number 2 was residing to check whether Ratha lives there, they drove down 24 hours. He then imitated the sound of a car at roo, as they were traveling there. They're going to check where Ratha lives. And Colonel Mngomezulu, they would have told him to go and verify his address for us. In hindsight, you are right. But that is how our police operate sometimes. The judge said that he's arguing the same. So he's giving
this so that he can justify at the end of the day on behalf of this police. Like, come on, man. Continue.
The event on the 19th of June, when accused number 2 was booked out again for him to be taken to Foslera's court for the Nongoma case 163 of 2019, then they received a call from Brigadier Gininda to deviate and take accused number 2 to Colonel Rapadu. The matter was not placed on the roll, and then they went to look for the hoodie and they found ammunition. Ntanzi was taken to his place in Rustenburg and police discovered ammunition. What a coincidence, Ramosepeli said. What are the probabilities? And the judge cautioned Ramosepeli against arguing like that, saying that there were 2 different versions of what happened in Rustenburg. Ramosepeli argued that Ntanzi's torture was done through sleep deprivation as well, and prolonged hours of investigation from the morning on the 18th of June 2020 to the next morning. He was in the hands of police officers. That is perpetuation of torture. Ramosepeli said accused number 2 was in handcuffs for hours, deprived of sleep. He says water was poured on him. He says we submit that is perpetuation of torture. And on the aspect of Mjiako, Ramosepeli said that he failed to consult with accused number 2 before the proceedings commenced in the magistrate court to familiarize himself with the matter facing accused number 2. Taking advice and giving advice, at no stage did they dispute that he is an admitted attorney on the roll. So the exhibit that the state provided does not serve the purpose for which Mjiako's evidence was contested. The judge wanted to know if it was contested on the aspect of what, and the judge reminded him that there were different versions submitted by the defense on this. Well, that version of Mjiako not being a lawyer was never submitted by the defense. It was submitted by the judge. So he can't remember that he's the one who brought it up now. He's trying to pin it to the defense. And the evidence that the state brought has nothing to do, honestly, with whether Mjiako got a mandate to represent accused number 2 or not. Ramosepeli said that Mjiako had no mandate. So regarding the issue of the cell masters, Ramosepeli said it would have been negligent of them to allow Mukhani to willy-nilly come in and enter the register. The judge said that there are 4 names, Mulife, Ramaja, and the guys in Tlhabane. So according to Ramosepeli, Ramaja and Mulife are in Tlhabane. Where are the ones from Gauteng police stations that Ntanzi spent most of the time in? Where are the people who filled in those occurrence books from those police stations? Because now, turns out the ones that came at the 11th hour, the names Mulife and Ramacha that came after the defense were kind of hammering on the OB entry books that it seems like they were filled by Mokhani. And they were not wrong to come to that conclusion, especially after Mokhani's testimony. There's no way testimony. The only time where he mentioned that there was someone who was responsible for entering the OB entries on the OB book is when he thought that they didn't want to cooperate with him or assist him with filling it in, and then he went himself and fetched the keys. That was his testimony. But every time he would book Ntanzi, there's no mention of the cell master. So the judge said that there were others at Valeria, and he said that he will check. He remembers that evidence. So Judge Ratha remembers that there were cell masters from Valeria who testified. Yes. Ramosepeli read the record where Mokhani said that they just registered Ntanzi in the cells of Phokeng, but he never went inside the cells at Phokeng. Signed by Sergeant Mokhani, it does not say that a cell master participated. The judge justified this to say that it was a transit book-in. They went to Primrose. There was no intention for the gentleman to be booked there and remain there. But then Mulife and Ramaja, where do they enter if that's the case? That's the question I have. Ramosepeli said whether in transito, that transito must still be written by the cell master. Mokhani just comes and signs, but it is written by him. The judge said no problem. So on the interpreter, Ms. Mutlaping, that was in the room when the confession before Magistrate Kunye was taken down, Ramosepeli said that they have never questioned the credentials of the interpreter. Ramosepeli said that they submit that the confession and pointing out must be inadmissible and that they are not freely and voluntarily taken. Well, that was it with the arguments or heads of argument for accused number 2's representation, which is Mr. Ramosepeli. Mnisi said that for the submission, he has not been part of the proceedings. So I was kind of disappointed with Mnisi not having prepared. I was looking forward to him. Presenting heads of argument as well, because I know that he was going to cover what was not covered. But I guess his absence in court over the last week it had an effect, And the judge joked to say that he thought Mnisi was a sangoma because the sangoma uyaboniswa, they are shown. Mnisi said he could not follow the submission on all the social medias, and he said that he went through the heads. He said that he's satisfied with what he has been captured by his colleague and as well as their oral arguments, and therefore has nothing to add but except one thing. That is something that came to him as he was standing there. That's what he said, and I quote, this is what he said. I don't understand what he was talking about, but hopefully you guys can tell me. He said the fact that in the grounds for the objection, in the admissibility of the confession, certain grounds are not specifically mentioned. And the judge said that he knew that Mnisi and himself knew that. And I could tell that he was kind of getting upset. Mnisi said you can come with 1,000,000 grounds, no problem. Okay, that was the judge saying that. And Mnisi said, but the fact that certain grounds are not specifically mentioned at the outset of the commencement of the trial within a trial, that is not a bar to the court to infuse whatever the court will deem as an irregularity on how the statements were obtained. To do so would be an indication that the court is adopting a piecemeal approach to the evaluation of the evidence. The judge said that he is aware of that. And unfortunately, the Supreme Court and Constitutional Court is well aware of how the evidence should be approached by the court, listening to the facts of the case. So you guys, any idea what he means? For me, this was too deep. Understand? What I could make a sense of is that, it disturbs Ratha somehow. But I don't understand how, because he even brought it up at a later stage. He even got a textbook to support that what Mnisi is saying is not what he's doing. So he's saying that he's collecting all the evidence, and what Mnisi is saying is not what he is doing. He says he collected all the evidence. Malo said that he won't make any submissions on behalf of Mapisa, and Mshololo said that he stands by the heads which have been elaborated by Ramosepeli and Mngomezulu. Mshololo was asking that they be done as they are arguing. Actually, she pointed out that Mr. Mngomezulu's heads of argument had not been interpreted yet, and Ramosepeli was now done, and Mnisi said something. And considering the interpreter also summarizes everything, let us just say Gutsi Ziyakhala for the accused, okay? If they cannot hear English, hi Ziyakhala ngampela. And the judge said that it would be awkward if now the interpreter was to interpret everything that the counsel was saying. If the counsel coughs, then the interpreter will also have to cough. I don't, guys, miracles in that courtroom. I don't understand. When did it become a problem for the interpreter to interpret for the accused? Well, Advocate Baloyi for the state addressed some of the points raised, and he read the definition of what is a justice of the peace. With regard to Mngomezulu's argument that the police officers who claim to be justices of the peace did not prove that is what they are, and they did not provide the documentation that supports their claim, Baloyi said that there's no need for them to produce appointment certificates. They are exequial justices of the peace. Baloyi also said that the interpretation had to be proven, whereas the accused denied it, and that they made the confession. In his reply, State Prosecutor Judge Baloyi maintains that no assault took place and that the accused's rights were explained to them. He said, "We stand by our submission that there was no evidence of assault." Baloyi said in regards to sleep deprivation, there is no evidence that there was a deliberate act to influence the will of the accused, and there's no evidence that the police did anything to try and bend the will of the accused. The judge reminded him of a judgment he can quote to support this, which is Scouts, and Baloyi said there has to be a connection between the assault as well as the making of the statement. The judge asked him if it is the case of Muchininda. That's another case where his brother Mutata was appearing. Judge Mutata, appearing in 1999. And school said you do not appear into the trial within a trial as well as the main trial, but one-way class. You can look into what was said in the main trial, but you cannot, when you are busy with the trial within a trial, look into the main trial, which is something that I also struggled to understand, but Mr. Anonymous explained it to me the last time we were live, so I get it. Regarding the J50, Baloyi said that Brigadier Gininda has sufficiently dealt with that aspect. The evidence is to the contrary. The Tembisa case, that case, it's now being dragged here now, was taken to court and went through its paces in court. There was just a cause to obtain the warrant against accused number 1 and possession of firearm and ammunition case. Was Brigadier Gininda the investigating officer of the firearm and ammunition case? Do you guys know if he was the investigating officer of that case or not? Well, I don't know. I still have to make sure, right? So that's the case we talked about here. I don't remember if the investigating officer was mentioned. I don't know who it is. So Baloyi said that the evidence of accused number 1 was vague, and there's no mention of the police officer he reported to, and he did not do a follow-up. So that's it, guys. That's pretty much what happened. And of course, the judge defended himself. He defended whatever he could defend. Especially regarding Advocate Mnisi's statement. For me, it's a wrap.
Yeah, it's a wrap, guys. Thank you very much. Please, no calls today. We started late, so there is not going to be calls today. I'm sorry.
Maybe we'll do it tomorrow.
Right.
Hopefully. You guys let me know in the comment section down below. We'll open the lines tomorrow if we go live.
Yeah, thank you guys. Please like the video on the way out. Thank you very much.